Big news out of the Supreme Court. The Chief Justice of the United States of America just issued a rare statement on President Trump's call to impeach the judge in his Alien Enemies Act case. I want to go straight to Paula Reed. Paula, wow, this is a very big deal.
This is a huge deal. Here you have Chief Justice John Roberts appearing to push back on statements President Trump made earlier today, suggesting that a judge, James Boasberg, who of course temporarily blocked deportations by the Trump administration, or at least tried to, should be impeached. And here the Chief Justice writes, "For more than 2 centuries, it has been established that impeachment is not an appropriate response to disagreement concerning a judicial decision. The normal appellate review process exists for that purpose."
Hey people, Adam here. So what just happened today? A unanimous federal appeals court delivered 4 words that changed everything. Former President Trump has become Citizen Trump. No poetry, no drama, just a constitutional fact stating he's subject to the same criminal laws as every other American. The court went further. They wrote that accepting Trump's immunity theory would collapse our system of separated powers by placing the president beyond the reach of all 3 branches. Beyond the reach of all 3 branches.
A New York judge has rejected President-elect Donald Trump's request to throw out his conviction in the criminal hush money case. Judge Juan Merchan said in a court filing Monday the Supreme Court's ruling giving presidents immunity from prosecution over official acts does not apply to this case. A jury convicted Trump in May on 34 counts of falsifying business records to conceal hush money payments to adult film actress Stormy Daniels in the lead up to the 2016 election. Trump's sentencing had been delayed while the judge considered the impact of the Supreme Court's ruling.
The legislative branch through impeachment, the judicial branch through criminal prosecution, the executive branch through enforcement of court orders. All of it gone. All of it eliminated. That is what the court said the immunity claim would produce. And then the court rejected what they called the impeachment first theory. Trump's lawyers had argued that he could only be criminally charged if he was first impeached and convicted by Congress.
No person is above the law, not even a U.S. president. That's what Special Counsel Jack Smith is arguing in a brief to the U.S. Supreme Court, urging the justices to reject Donald Trump's bid for immunity from prosecution on charges of plotting to overturn his 2020 election loss.
And they're not taking this White House. We're going to fight like hell.
Smith filed the brief Monday before the justices hear oral arguments on April 25th over Trump's presidential immunity claims. In his brief, Smith said, quote, "The effective functioning of the presidency does not require that a former president be immune from accountability for these alleged violations of federal criminal law. To the contrary, a bedrock principle of our constitutional order is that no person is above the law, including the president."
The D.C. Circuit called that argument extraordinary and warned it would place presidents above the law for all time. Above the law for all time. Those words are in a published federal appeals court opinion, written by judges, signed by judges, binding as precedent. But here is where this story gets even more alarming. The Supreme Court then issued its own ruling in Trump versus United States, and while the Supreme Court did not give Trump everything he wanted, what they did give him has constitutional scholars and civil liberties organizations issuing warnings that should terrify anyone who cares about accountability. The ACLU and constitutional lawyers say the Supreme Court gave Trump dangerously broad immunity for core official acts. Absolute immunity for anything the court deems a core presidential function, presumptive immunity for other official acts. And only then, only after those 2 layers of protection, does any conduct become chargeable. The Supreme Court sent the case back to the trial judge to sort out which acts are official and which are private. That process is happening now, count by count, act by act. And the legal team that once argued for a blanket shield against any prosecution at all is now fighting on what commentators call narrower, more technical terrain. They are freaking out. And I am going to tell you exactly why. Stay with me, because I am going to break down exactly what the D.C. Circuit said, exactly what the Supreme Court did, exactly why the immunity stripping is more devastating than it first appears, and exactly why the legal team's freakout is completely justified. Let me start with the complete documented picture of the immunity fight, because every alarming element is grounded in actual published court opinions from actual federal courts in the most formally verified judicial accountability format. The February 2024 unanimous D.C. Circuit three-judge panel rejection of Trump's blanket immunity claim is published in a formal federal appeals court opinion. The specific language that Trump lacked any lawful discretionary authority to defy federal criminal law is in that published opinion. The collapse our system of separated powers language is in that published opinion. The citizen Trump formulation is in that published opinion. The Supreme Court's Trump v. United States ruling subsequently established absolute immunity for a narrow core of official acts, presumptive immunity for other official acts, and no immunity for private or campaign actions. That ruling is in the most formally published Supreme Court opinion available. The vacating of the D.C. Circuit ruling and remand to the trial judge to sort official from private acts is documented in that opinion. And the ACLU and constitutional lawyer warnings that the Supreme Court gave dangerously broad immunity for core official acts while leaving private election subversion conduct chargeable are formally published in credible legal commentary. Every judicial determination has a formal published opinion. Every quoted phrase is from an actual court document. And the combination creates the most comprehensive picture of the immunity fight trajectory in the most multiplied, judicially authenticated accountability record. Now let me focus on the most important clarification in the entire immunity fight. The D.C. Circuit did not say presidents have no immunity whatsoever. That is not what the ruling said. What the D.C. Circuit said was that Trump cannot block this prosecution by claiming a blanket shield for everything he did to cling to power after losing the election. That distinction is critical. A total immunity ruling would have resolved the case in Trump's favor without any examination of what he actually did. A blanket shield rejection forces the most detailed examination of what he actually did on a count-by-count basis. The blanket shield rejection is more alarming in some ways than a total immunity denial would be, because it forces Trump's legal team to engage with the actual conduct alleged, rather than hiding behind the most sweeping procedural barrier. Now let me talk about the impeachment first theory, because this is where the D.C. Circuit's language gets truly extraordinary. Trump's lawyers argued that he could only be criminally charged if he was first impeached and convicted by Congress. The D.C. Circuit specifically and formally rejected that theory, calling it an extraordinary claim that would place presidents above the law for all time. A legal theory that places presidents above the law for all time, most specifically and most formally, eliminates the most fundamental constitutional accountability mechanism for the most extreme presidential misconduct. The above the law for all time characterization from the D.C. Circuit is the most dramatic judicial rejection of the most extraordinary immunity theory, and its specific formal publication in a unanimous three-judge appeals court opinion makes it the most credible institutional confirmation of the most fundamental accountability principle. Now let me talk about the Supreme Court's three-tier structure, because this is where the legal team's freakout is most justified. The Supreme Court established absolute immunity for core official acts. That means any conduct the court deems part of a president's core constitutional functions is completely immune from criminal prosecution. No charges, no trial, no accountability. The Supreme Court established presumptive immunity for other official acts. That means other official conduct is presumed immune unless prosecutors can overcome that presumption with a compelling justification. That is a high burden, and only then, only after those two layers of immunity, does the Supreme Court say there is no immunity for private or campaign actions. That means the conduct that can actually be prosecuted is limited to what the trial judge determines is purely private conduct, not official in any way. The ACLU and constitutional lawyers warned that the Supreme Court gave Trump dangerously broad immunity for core official acts. That is not a partisan political statement. That is the assessment of the American Civil Liberties Union and constitutional scholars. They are warning that the core official acts immunity is so broad that it could swallow vast amounts of conduct that look very much like the election interference alleged in this case. At the same time, they underscore that private election subversion conduct can still be charged. The question is whether the trial judge, on a count-by-count basis, will determine that the conduct alleged is private rather than official. That determination will make all the difference. The three-tier structure requiring count-by-count analysis of whether each specific alleged act falls into the absolute, presumptive, or unprotected tier is the most alarming consequence for Trump's legal team. It forces detailed examination of actual conduct rather than a blanket procedural dismissal. Before the immunity rulings, Trump's lawyers could argue that he cannot be prosecuted for anything he did as president, up to and including using the Justice Department to pressure states or push fake electors behind a blanket procedural shield. After the rulings, his team must fight on narrower, more technical terrain, distinguishing official from private acts on the most specific count-by-count basis. Narrower, more technical terrain is the most practically alarming legal strategy consequence. It eliminates the sweeping procedural barrier and forces detailed engagement with what Trump actually did. Now let me take you deeper into three specific dimensions of this story that each deserve careful attention. The first dimension is the constitutional significance of the Citizen Trump formulation. What does that judicial sentence most specifically establish as a constitutional accountability principle? The Citizen Trump formulation most specifically invokes the most fundamental constitutional accountability principle, that the most powerful political figure is subject to the same criminal laws as every other American citizen when that political figure is no longer exercising constitutional office. A former president who claims blanket immunity from criminal prosecution based on prior office holding is claiming a permanent exemption from equal justice under law. The Citizen Trump formulation directly and formally rejects that permanent exemption claim. The collapse separated powers language deserves its own attention. The D.C. Circuit wrote that accepting Trump's immunity theory would collapse our system of separated powers by placing the president beyond the reach of all three branches. The separation of powers is the most fundamental structural principle of American constitutional governance. A president who is beyond the reach of all three branches is exempt from every institutional accountability mechanism: legislative accountability through impeachment, judicial accountability through criminal prosecution, and executive accountability through enforcement of judicial judgments are all simultaneously eliminated. The beyond the reach of all three branches characterization is the most catastrophic constitutional governance outcome. The D.C. Circuit unanimously identifying that catastrophic outcome as the specific consequence of accepting Trump's immunity theory is the most formal judicial rejection of the most constitutionally threatening legal argument. The second dimension is the Supreme Court's three-tier immunity structure. What does this structure mean for the realistic prosecution landscape? The absolute immunity tier for core official acts protects the most central presidential functions, including communications with senior executive branch officials and use of core presidential powers, from any criminal prosecution. The presumptive immunity tier for other official acts creates a rebuttable presumption that other official conduct is protected unless prosecutors can demonstrate a compelling justification to overcome it. The no immunity tier for private or campaign actions exposes personally motivated conduct, including private communications advancing election interference goals and campaign coordination activities, to criminal accountability without immunity protection. The three-tier structure requiring count-by-count analysis of official versus private conduct is the most alarming consequence for Trump's legal team because it forces detailed examination of actual conduct. The no immunity for private election interference conduct tier is the most specifically consequential prosecution pathway. The third dimension is what commentators have identified as the most politically significant consequence of the immunity fight. The more Trump leans on immunity, the more these rulings remind voters that his main defense is not innocence, but a claim that the law simply should not apply to him. A defendant who claims innocence asserts that they did not commit the conduct alleged. A defendant who claims immunity asserts that even if they committed the conduct alleged, the law does not apply to them. The immunity defense implicitly concedes the conduct while claiming legal exemption from accountability. Commentators specifically identify that implication as the most publicly resonant voter perception consequence. The innocence versus above the law defense distinction is the most broadly available political accountability assessment of the immunity defense character, and it is the most broadly available democratic accountability analysis. The unanimous D.C. Circuit three-judge panel's Citizen Trump formulation, combined with the collapse-separated powers beyond the reach of all three branches language and the above-the-law for all-time rejection of the impeachment first theory, together most specifically establish the most formally available and most judicially authenticated expression of the fundamental constitutional accountability principle, that former office holding does not permanently exempt the most powerful political figure from equal justice under law. The unanimous character is the most credible institutional confirmation of this determination. The Supreme Court's three-tier immunity structure, combining absolute immunity for core official acts, presumptive immunity for other official acts, and no immunity for private or campaign actions, most precisely establishes the post-ruling prosecution landscape requiring count-by-count official versus private act analysis. The no immunity for private election interference conduct tier is the most specifically consequential prosecution pathway. The count-by-count analysis requirement is the most practically alarming legal strategy consequence, forcing examination of actual conduct rather than blanket procedural dismissal. The narrower, more technical terrain characterization of what blanket shield rejection requires from Trump's legal team, combined with commentators noting that immunity leaning reveals the main defense is not innocence but that the law should not apply, most precisely establishes the dual legal and political consequences of the immunity strip rulings. The conduct examination forced by blanket shield rejection is the most alarming legal consequence. The innocence versus above the law defense distinction is the most broadly available political accountability consequence. Here is exactly what you need to watch as this story continues to develop. Watch the trial court count-by-count official versus private act analysis for any judicial determinations that identify which alleged election interference acts fall into the no immunity private conduct tier. Watch any additional immunity appeals for signals that the official versus private act distinction is being contested on specific factual grounds. Watch the political communications response for signals that the immunity-leaning defense posture is producing voter perception consequences in competitive electoral districts. And watch the ACLU and constitutional lawyer commentary for formal assessments of how the dangerously broad core official act's absolute immunity is being applied in practice. Let me leave you with the absolute bottom line. A unanimous three-judge D.C. Circuit panel wrote that for the purpose of this criminal case, former President Trump has become Citizen Trump, rejecting his blanket immunity claim, finding he lacked any lawful discretionary authority to defy federal criminal law, and ruling that accepting his theory would collapse our system of separated powers by placing the president beyond the reach of all three branches. The court rejected the impeachment first theory, calling it extraordinary and warning it would place presidents above the law for all time. The Supreme Court subsequently established a three-tier immunity structure with absolute immunity for core official acts, presumptive immunity for other official acts, and no immunity for private or campaign actions, requiring count-by-count analysis of official versus private conduct. The ACLU and constitutional lawyers warned the Supreme Court gave dangerously broad immunity for core official acts while leaving private election subversion conduct chargeable. Commentators noted that the more Trump leans on immunity, the more these rulings remind voters that his main defense is not innocence but a claim that the law should not apply to him. The blanket shield rejection forcing narrower, more technical terrain and count-by-count conduct examination is the most practically alarming legal strategy consequence, requiring detailed engagement with what Trump actually did rather than hiding behind the most sweeping procedural barrier. The Citizen Trump formulation is in a published federal appeals court opinion. The collapse-separated powers language is formally documented. The three-tier Supreme Court structure is in a published Supreme Court opinion. The dangerously broad warning is from the ACLU. And the story of Trump's legal team freaking out after immunity was stripped is the most specifically alarming and most comprehensively documented real-world expression of what it means for the most fundamental above-the-law legal theory to be rejected by both a unanimous federal appeals court and the Supreme Court, leaving the legal team to fight on the narrowest factual terrain rather than hiding behind a blanket procedural shield. We are going to be right here watching every single development as this immunity strip accountability story continues to unfold. Drop a comment below and tell me what you think. Does the no immunity for private election interference conduct tier produce the most consequential criminal accountability through the count-by-count prosecution pathway? Or does the dangerously broad core official acts absolute immunity and procedural delay strategy contain private conduct prosecution below the criminal trial threshold, despite the most comprehensively documented immunity strip determination? I want to hear from you. I will see you in the next one.